The information provided in this podcast is for general purposes only. Individual legal situations vary greatly, and viewers needing individual legal advice should consult directly with an attorney. Eligible ATPE members may contact the ATPE Member Legal Services Department. Hello, and welcome to the ATPE Podcast, brought to you by the Association of Texas Professional Educators and covering the hottest topics on Texas educators' minds today.
Welcome to the ATPE Podcast. I'm David George, editor of ATPE News, and today we're wrapping up our three-part series on educator leave. So far, we've covered both paid and unpaid leave and protected leave, like FMLA and TDL. In this final episode, we're focusing on miscellaneous types of leave, some required by law, others offered as part of a district policy. Joining me again is Lance Cain, ATPE's managing attorney. Welcome back, Lance.
Thanks, David. Glad to be part of the ATPE podcast. And I know you're going to be asking me a lot of questions today, so I thought I would start off with a question for you. Do you know why it's called a podcast?
I have no idea.
Yeah, actually, I didn't know either, but it goes way back to 2004. If you can imagine a time 20 years ago, 21 years ago, it's a combination of iPod and broadcast. And now it's not only iPods that they use, but I guess that name stuck.
That's really interesting. I haven't thought of an iPod in at least 10 years.
Right?
But I'm really glad we get to use this channel, and I think that this is a good platform for talking about this because I actually have a ton of questions for you today.
Well, yeah, let's get into it. And yeah, this is going to be a little bit all over the place, but it will sort of wrap up the previous two podcasts that we did on leave and kind of these are sort of just, miscellaneous ones, like you said, that are important to know. Sometimes they're available to members depending on the district policy. Sometimes the district doesn't follow that or doesn't have that particular benefit. But yeah, it's something that definitely good to cover these types of extra types of leave.
Well, let's start with something that's uniquely relevant to school employees, and that's assault leave. Can you give us a quick overview?
Yeah, assault leave provides protection for school district employees who are assaulted while at work and who need time off to recover. It only covers physical injuries sustained from the assault, so any kind of mental distress or PTSD or other non-physical injuries are not covered by assault leave. In addition to the assault leave, the employee may also be entitled to FMLA, TDL, or other types of leave. But yeah, if so, in other words, if they need time off for PTSD or something like that, they might be entitled to FMLA, but it doesn't cover assault leave. And we certainly know that nobody wants to be assaulted at work. But when that does happen, this law definitely helps. And it's good for employees to be aware of that because districts don't always notify employees of their right to assault leave.
Just quickly, who qualifies for this leave? You said district employees. Is that all of them?
Yeah, so this answer is kind of a good news, bad news kind of thing. The good news is that assault leave applies to any school district employee. So it's very broad. It's not limited to just teachers or certified employees like some other rights are. Now, the bad news is that to be eligible for assault leave, you have to have suffered a fairly serious physical injury. And so, serious enough at least that it requires some leave of absence for recuperation.
Well, how does the law define an assault in this context?
That's a good question because that is often the most disputed aspect of assault leave. So whether or not an assault actually occurred. The very basic definition of assault is just an unwanted physical touching. So as you can imagine, that might not result in any kind of serious injury. And so for assault leave, we're usually dealing with something that's a lot more serious since it does require an injury that's substantial enough to cause some kind of absence. And sometimes an assault is very, easy to define. Like if a student intentionally, walks up to an employee and kicks or punches them. But assault leave, it also doesn't necessarily follow the same rules as criminal prosecutions because an assault for the assault leave statute, it can apply even if the assailant cannot be prosecuted due to their age or mental capacity, which is important in a school district context. And then the issue of whether something is an assault, it can get pretty complicated, and unfortunately, some of these scenarios that we see most often are because the district is disputing it, and then that way, or that's why a teacher or member will call us. So I'll give you a few examples of that. So like, let's say a student is acting out, maybe putting themselves in danger or another student at risk, and they're not following the teacher's verbal directives. So the teacher, usually they'll call for help from administration, but then they have to deal with the situation immediately happening in their class. So they may attempt to restrain the student for the student's own safety. And then during that struggle, even if the student might not kick or hit the teacher ends up hurting themselves, or hurting their back or twisting their neck or something. And it can depend on the facts, and districts certainly don't always agree. But here, in a situation like that, there's definitely an argument that an assault occurred. Another pretty common scenario that we see where districts might question whether there was an assault is when a teacher tries to intervene to break up a fight between students. And then sometime during that, sort of intervention, the teacher's injured. And so while the district may take the view that it's not an assault against the teacher, there's definitely some legal precedent for assault leave to be applied because of the idea of sort of transferred intent. So the student was, intending to assault or fight another student or whoever they're fighting with, and then that sort of intent transfers over to the teacher, who might get hurt with a stray punch, or maybe just the same situation as the restraint, where they twist their back or fall over, something like that. Another example that we've seen is sort of recklessness. That could come up even if the student was like horse playing. So like they run up behind a teacher and jump on the teacher's back. That's actually a case. And so that one was found that there was an assault there, because there's sort of a recklessness, like the student should have had an awareness that an injury could occur.
Now, is that considered paid leave?
Yes, that's a very good, important part of it. The employee receives full pay while they're on assault leave. Though I will note that the pay doesn't always come entirely from the district, because assault leave, it involves an injury at work, and so workers' compensation is nearly always involved. Assault leave benefits are typically coordinated with workers' compensation, the temporary income benefits, and that's approximately 70%. So in a lot of cases, the district ends up paying sort of the difference. So the employee should get their total compensation, 100% of their total pay. Excuse me. Now, the workers' compensation doctor's note is usually pretty important documentation for establishing assault leave. So what they write, or what they say on their medical report can sometimes make a big difference. Because it's often the case that when the employee is released to work, the assault leave is basically over because they're no longer recovering from the physical injuries. But we've had clients who the district actually won't allow them to return to work, sort of a risk management thing. So that maybe they have restrictions or something, but the district doesn't want to have them back. And I think that actually gives the employee an argument that the assault leave should then continue. Because it's the district now saying that you're not physically able to return to work. And so since the workers' comp portion has ended, that actually puts the district on the hook for the full 100%. So that's something that we run into, and sometimes districts quickly sort of change their mind on that when they realize that they're having to pay the employee to not show up to work. But it is something, in terms of pay, it's a really good benefit because it doesn't count against the it doesn't count against the employee's paid leave, and they should receive full pay.
Well, some injuries are going to be more severe than others, and so it may take longer to recover. Is there some sort of limitation on how long you can take this type of leave?
Yes, like you said, there are differences. So the leave itself lasts for the number of days needed to recover from the physical injuries. That varies depending on the injury. Now the maximum it is in the statute. It's a 2-year maximum amount of leave, amount of paid leave, and so that's a pretty good amount of time. In very unfortunate situations where a teacher might be sort of permanently disabled, that would be, entitle them to the 2 years of pay, and then hopefully they would have some type of long-term disability or retirement disability. But yeah, the 2 years is a really good benefit, and it gives them, a little peace of mind during a really hard time.
Well, how does an educator go about requesting assault leave?
In my experience, it's best to specifically request that by name, because, like I said, districts don't often, bring it up, and when possible, create some type of documentation of the request. So, if you verbally request it from your principal or human resources, it's a good idea to also follow up with an email so there's a record of that request. If there's any sort of incident or injury report that the district requires you to fill out, it's a good idea to fill that out. And then if there's any sort of accompanying doctor's note, whether it's a workers' comp doctor or your own doctor, then you can provide that sort of as a supplemental documentation. And there's actually no statutory deadline for requesting it, but it is a good idea for the employee to request it within a reasonable amount of time. Courts have held that that requirement to do it sort of a reasonable amount of time. I think there was one case where someone waited 2 years and they said that was too long. So delaying a claim can reduce the likelihood it will be approved. Plus, in situations where the facts are a little bit murky, the more time that goes by, the more difficult it is to investigate. So a really good idea to try to get it requested as quickly as possible. Now, sometimes I understand. I mean, it might be where, at first you don't think that you're hurt or you're injured. Maybe a day or two goes by, and then you start to feel, the after effects, or feel some pain. You go to doctor. So in those situations, that's completely understandable. It is good in that case to try to get it tied back, to the incident at work or to the assault. So the assault leave, so the documentation will be more supportive.
Well, let's switch gears here and talk about civic duty leave.
Hmm.
What qualifies as civic duty under Texas law?
Yeah, so that's basically time off for employees to participate in certain civic duties or responsibilities. We're talking things like jury duty, when you respond to a call for jury duty, witness duty, that's like appearing in court or before some type of governmental body pursuant to a subpoena or a summons. Um, Usually in those cases, it the district's, I guess, obligation to pay, or their willingness to pay might depend on kind of what the subject matter of the lawsuit is. If it's something where, like, you're suing, your business or something, you're suing a business or something, they're probably not going to cover that. But if it's a subpoena, a lot of times what they'll get is, a teacher will get a subpoena to appear in a divorce or custody hearing involving two of the parents of a child in their class. Those districts are pretty understanding about, and so we do see a lot of that. Voting is another one. There's some laws that require not only school districts but all employers to sort of let people have time off for voting, and then other potential civic duties. Some policies may include time off for if someone is, like, in a volunteer search and rescue group, firefighting, other things like that. Those are more at the discretion of the district.
So you said that these are typically paid leave situations. How is that determined?
It can depend. Yeah, it depends on the type, and then in some cases, the district policy. So it might be discretionary where the district agrees to pay it. For jury duty or a subpoena, the school districts are not required by law to pay employees. Um, but as I was kind of getting to, many districts do compensate employees when the jury duty or the witness appearance relates to their employment. So, like in a child custody case, um, employees are usually required to remit some type of jury or sort of witness paperwork, to prove that they were there. And then if the subpoena or court appearance is unrelated to their job, then they're usually going to require the employee to use paid leave. Voting is another one. So employees in Texas are allowed paid time off to vote on election day, unless that employee has at least 2 consecutive hours to vote outside of their working hours. But a lot of districts will kind of make it a little bit more generous than that. And then for any other type of civic leave, just check the district policy, because that'll tell you whether or not it's going to be paid leave or kind of what other requirements that you need to fulfill.
Are there any limits or conditions that educators should know about?
Yeah, the civic duty time is usually limited to the time necessary to sort of fulfill those obligations, and then reasonable travel time. So employees may be required to return to work early, if they're released early from the jury duty, and then also districts can set restrictions on the use of personal leave. They might prohibit discretionary leave on certain days or limit the number of days taken consecutively. So these restrictions, they may not apply to non-discretionary civic duty leave like jury duty. So yeah, sometimes there's sort of an exception to those if you're required to go in and go to jury duty or a subpoena.
Can educators be penalized for taking civic duty leave?
Generally speaking, no. A school district should not discharge or discipline or reduce the salary of or otherwise penalize or discriminate against a school district employee for taking that civic duty leave.
Let's shift gears again, this time to military leave under USERRA. What does this law cover?
Yes, USERRA. Okay, so that stands for the Uniformed Services Employment and Reemployment Rights Act, and it is a federal law that safeguards the employment rights of service members, and so it ensures that they can take military leave without fear of losing their civilian jobs or facing any kind of discipline or discrimination. And it applies to all public, private, and government employers in the United States, regardless of their size. So some laws have size restrictions like FMLA. Some federal laws only apply to government employers, but this one it covers the whole spectrum.
And just to be more specific, who exactly qualifies?
So yeah, so USERRA has sort of a pretty broad list of protected individuals, and that's past or present members of the uniformed services, including reservists, National Guard members, applicants of uniformed services, and then if you're obligated to serve in a uniformed service. So it's really, yeah, if there's any kind of connection to any kind of uniform service, you're generally going to be entitled to USERRA rights.
Well, how long can someone be gone and still return to their job?
So generally, the reemployment rights are retained for up to 5 years of cumulative service with the same employer. So there's some exceptions, but yeah, it's a pretty substantial amount of time.
And what about their health benefits or retirement?
Yeah, so and that can depend on the length of the service. If it's over 30 days, then the employer-sponsored healthcare can continue for up to 24 months with the premiums potentially entirely covered. If we're talking service less than 31 days, the coverage continues as if you're employed. So in other words, if you pay 50%, then you continue to pay the 50% of your health insurance. Upon reemployment, you're supposed to sort of have immediate reinstatement into the health plan with no waiting period and no exclusion for non-service related issues. And then in terms of retirement, USERRA treats the military service as continuous for pension purposes. So employers must continue to contribute as if the employee was continuously employed. And then when they apply for reemployment, they're entitled to any seniority or status or pay that would have been achieved if not for sort of absence. They call that the escalator principle.
Are there any steps that they should take before leaving?
Yeah, to the extent that they can, they should notify their employer and provide necessary documentation. And I say to the extent that they can because sometimes, maybe their military employment would or deployment would prohibit sort of providing that information. But yeah, most of the time they're going to have some documentation of that they can provide to the district.
Well, let's talk for a second about a leave type that we've heard a lot, and that's administrative leave. Can you tell us what that is?
Yeah, administrative leave is something that you do hear about, and not just with regard to educators. I think it's common in other, industries as well. You hear about it with police sometimes if there's an incident. So basically, it's a temporary removal of your work duties. It's typically initiated by the employer, and then it generally involves paid leave with the benefits intact. But with school district employees, there are some exceptions to that. Um, and then the standard for placing an employee on administrative leave is pretty low. So it's not considered a negative employment action. So there at the time that the employee is placed on administrative leave, there's not really a due process right to challenge it. Um, a lot of times it involves an investigation into alleged misconduct. This is a really common reason. So it sort of allows a district to conduct a thorough investigation without the employee being present on the campus. And sort of the actual standard is just really in the best interest of the district. So if the superintendent decides that it's necessary to place an employee on administrative leave, they can do so if they feel that it's in the best interest of the district. Um, one of the I guess reasons or benefits that I've heard of districts saying is that it sort of protects the employee, protects sensitive information. Maybe there's a situation where the employee is a whistleblower or has sensitive information relating to an ongoing investigation, so that can sort of insulate the employee from that. Um, and then finally, we see it happen when the employee needs to be removed from the workplace due to some type of disruptive behavior or violation of policies. And then, as I said earlier, an accusation of misconduct.
So I hate to sound like a broken record here, but this is typically paid, but it depends.
That's right. That's right. Yeah, so it depends on the type of the employee and then also their contractual status. So if you're an at-will employee, um, that might be an aide, teacher's aide, or a cafeteria worker, or bus driver. You're usually not going to be legally entitled to administrative leave with pay. Though a lot of districts will sort of voluntarily do that, at least initially. Sometimes they'll change it sort of midstream. On the other hand, if the employee has a contract, they're generally going to be entitled to administrative leave with pay. It can depend on the contract, like if you have a Chapter 21 teacher contract versus say like technology director contract. But the Chapter 21 contracts are entitled to paid suspension unless the district finds that there's good cause to suspend them, sort of in lieu of discharge. So very serious cases. But that process does require due process for the employee. So yeah, they have some protections there.
So being placed on administrative leave is much more like a suspension than being fired.
Yeah, it is. It is. It's not good. I mean, it's definitely you don't want to be on administrative leave. And I mentioned earlier that it's not considered a negative employment action, but it's not positive. So and it's probably I wouldn't even consider it neutral because a lot of districts will ask on their applications if you have been ever put on administrative leave, and I think having to say yes to that could raise some red flags. But no, administrative leave does not mean that you're going to be fired. It's usually a temporary measure during the investigation. Many employees return to work, but the outcome of the investigation, it could lead to termination depending on the facts.
Now, is there anything that you should or shouldn't do while you're on administrative leave?
Yes, it's important to follow district directives or administrative directives that you receive. A lot of times they'll give you some sort of a memo or something with a list of things that they want you to follow. Um, it's a good idea to request clarification on the leave status and try if you can to find the reason for the administrative leave. I like to recommend documenting everything and then consider consulting an employment attorney. Usually advisable to cooperate with the investigation, but that's something that can depend on the allegations themselves. If we're talking something pretty minor, probably good idea to cooperate, or if you're just going to deny the investigation or deny the allegations, might be okay to say that. But it can become complicated if the allegations involve criminal conduct. So in that situation, I would definitely recommend trying to consult with an attorney. Um, and like I said, usually the employees are given some directives like not to communicate with colleagues. That can become awkward depending on how long the leave lasts, especially if you socialize with colleagues outside of work or run into them in public. And then, sometimes a friend or colleague will just text you. They'll say, what's going on? It's really best if you can not to reply. But I've had to advise some of my clients, you keep getting these texts or emails or calls from colleagues and friends. So go to HR, explain the situation, and get some advice from HR on how they want you to respond or whether they want you to respond to those types of things. Because if you're on administrative leave for something and then you are violating the directives that you're given while you're on administrative leave, that can sort of compound the negative things against you. Another pretty common restriction is sort of not attending district events. And that can also pose a problem for employees who have children participating in extracurricular activities, or I had one fairly recently who wanted to go attend their son's graduation. In those situations, I recommend that they reach out to the district administration, sort of ask permission to attend that specific event. It can definitely depend on the severity of the underlying allegations, but a lot of times for minor infractions, the district is going to allow someone to watch their child's event. So yeah, it really just, communication is key in that situation.
Well, before we wrap up, can you briefly touch on some other common types of leave, something like bereavement leave or even sick leave banks?
Yeah, those are kinds that aren't required by law, so they're what we consider discretionary. And I'll talk about sort of the sick leave banks and pools. A lot of districts do have those. And basically they both provide additional paid leave when an employee has exhausted their own paid leave balance. The sick leave bank is usually referring to sort of a district created benefit where the employee can voluntarily elect to join. Usually it requires them donating a set number of their own paid leave days to sort of get entry into the bank. So some districts require maybe a one-time donation, like 1 to 3 paid leave days. And I've seen some that sort of require a donation every year. So usually just maybe if you donate 1 day per year, you can become a member of the bank. The other kind, sick leave pool, usually that means it's a process where the employee can ask for a pool to be established for other employees to donate days to. So the other employees donate their own days to that. They usually will have pretty specific guidelines. Both of those types do. Most require the employee to suffer some kind of catastrophic injury or illness. So it's not something that, you get the flu or something like simple like that. It's usually pretty serious. Also, the employee usually has to exhaust all of their own paid leave before they can get entry into the sick leave bank or pool. And then in terms of the seriousness, some districts have pretty specific definitions, like I've seen requiring inpatient treatment, things like that. And then since they're district created benefits, there's a lot of variations out there because districts sort of have their own different rules on that. Some don't have any policy on those, so there's no sick leave bank or pool. And some only cover the employee, some cover injuries to close family members. And there's variations on how long that can last or how many days you can get. And so it's best to check the district policies on that and kind of know what the specific benefits are. But those are usually, they're pretty good benefits. Extended leave is it's not extremely common, but it is a benefit that a few districts offer. It's the same as sick leave, pool, and bank. It's discretionary, and it's similar to those in that it provides additional days, paid leave days, to the employee who's suffering some type of serious illness. But unlike the other one where it's involving donated days, this is usually where the district covers it themselves. So I've seen that a lot of them have there's some kind of usually some type of cap that where they limit it to a certain number of days. And also it's common for the days to be at a reduced rate. So either a percentage of the employee's sort of normal pay, or sometimes the districts will deduct like how much it costs to hire a substitute. But that's something to check into. If you're in a serious situation and you've run out of your own paid leave days, those are definitely three things that I recommend checking: a sick leave pool, sick leave bank, or extended leave, because those can all provide some additional relief for the employee and get them some additional paid leave while they're going through that difficult time. And then another one that you mentioned, bereavement leave. Quite a few school districts do offer some kind of specific bereavement leave. And a lot of times it is paid. So it's in addition to sort of the state mandated personal leave. There are a lot of variations, again, because it's a district created benefit. So it can vary between like who is eligible, and then the number of days that the district provides. Sometimes it's like up to 3 days. Sometimes it can be more. Also, there's usually policies on whether it can be used in conjunction with the employee's own paid leave. And then sometimes it covers certain types of family members. So there's different definitions of who it covers in that regard. And then sometimes they require documentation. Sometimes they don't. So it's a good idea also to check your district policies on bereavement leave, because if you have a close family member and you need that passes away and you need some time off to go handle that, that's a good idea to check your district policies and see what kind of benefits you have. If the district is going to provide additional pay and give you time off, really good idea to check into that.
Well, Lance, thank you so much for walking us through all of this information today. Really appreciate it.
Yeah, definitely. We encourage all of our members to contact us if they have questions about these issues. We're happy to walk them through it and provide any kind of assistance necessary.
Well, that wraps up our series on educator leave. Hopefully our listeners now feel more confident about what's available to them. If you have any questions or want to learn more, you can email us at comm@atpe.org. That's COMM@atpe.org. Don't forget to subscribe to the podcast and leave a review. Thanks for listening, and we'll see you next time on the ATPE Podcast.
Thanks for listening to the ATPE Podcast. For more information about becoming part of Texas's largest community of educators, please visit atpe.org.